In this podcast, we discuss the promise to pay part of an existing debt. Now, until now, we've been talking about what happens when someone tries to use a pre-existing duty as consideration for a new obligation. Now, we're going to consider whether part performance of an existing duty is sufficient consideration to discharge the existing duty itself. How does this arise? Well, sometimes a debtor, who's the person who owes the debt, tries to make a deal with a creditor. And in that deal, the debtor says, I'll pay you part of the debt if you choose to forgive the entire debt. So this is not even giving an undertaking to perform the pre-existing duty. Rather, this is the debtor promising to pay only part of the debt. So to perform only part of the pre-existing obligation. And the rule here is that payment of a smaller amount in satisfaction of a larger amount is not sufficient consideration. Meaning, a promise by a debtor to make a partial payment of a debt in return for the creditor's promise to accept a partial payment as a basis for treating the debt as fully discharged does not give rise to an enforceable agreement. This comes from the rule in Pinnell's case, which was an argument about part payment of a pre-existing debt was valid accord and satisfaction. And the agreement between the two is what the accord is, and what is given for the release of the debtor is called the satisfaction. But the rule says the promise of a smaller sum could not be satisfaction for the release. So basically, this would be you approaching your credit card company and saying, I owe you $10,000. How about I pay you $3,000 and you forgive the rest? So this is the situation we're talking about. First case is Folks and Beer. In this case, Folks was indebted to Beer for the amount, and Beer had obtained judgment. So what that means is Beer was the creditor, Folks was the debtor. Folks wasn't paying Beer. Beer took Folks to court and got a judgment saying that yes, Folks does in fact owe Beer a certain sum of money. After the judgment, the parties entered into an agreement under which Folks agreed to pay Beer regular installments until the full amount had been paid. In return for a promise that once payment was made, Beer would not enforce the judgment. And Folks made the requisite payments, but an action was brought by Beer to recover the interest. And the court here said that the issue was the agreement reached by the parties capable of being legally enforced? And determined that no, in fact, payment of a lesser sum does not, agreeing to pay a lesser sum does not invalidate the agreement to pay the original amount unless something extra was promised in exchange for the creditor foregoing part of the debt. Why? Well, first, there could be no complete satisfaction of the agreement as long as there's any future installment remaining payable. And it's impossible to treat a release as supported by any new consideration proceeding from the debtor. So there's the rule comes out of Folks and Beer. Folks and Beer relies on Pinnell's case, and Folks and Beer creates what becomes a pretty significant obstacle that the courts have had to deal with. The next case is Reselect Move, where over an extended period of time, Select Move failed to pay employee deductions to the Crown, and the managing director met with the tax collector to discuss the problem, and the tax collector asked for a proposal to deal with the money in arrears. The company made a proposal, and the tax collector allegedly said he would seek approval but would get back to the company if it was unacceptable. The company made payments, but not in strict accordance with the alleged agreement, and then the Crown demanded entire payments in arrears. And again, the issue, does the practical benefit of accepting part payment of a pre-existing debt constitute good consideration for the new agreement? and the ratio remains. A practical benefit gained in a new agreement whereby the debtor only pays part of the existing debt will not constitute good consideration in law. Now, first of all, the court here found that the Crown had not accepted the debtor's proposal, so there was in fact no new contract. But in the alternative, it went on to consider whether, if the Crown had accepted the proposal, was there sufficient consideration to support the new contract. It looked at Williams and Roffey, where a creditor and a debtor reach an agreement on the payment of the debt by installments to accommodate the debtor, and there's a practical benefit gained from this, then that agreement is upheld. So in Williams and Roffey, it was held that a practical benefit would constitute good consideration. Now, how about Williams and Roffey and its relation to Folks and Beer? Folks and Beer was not mentioned in Williams and Roffey. It wasn't argued. And so now that the court has a case before it that relies on Folks and Beer, the doctrine of precedent makes it impossible for the court to extend the principle in Williams and Roffey to the circumstances that are governed specifically by the principle in Folks and Beer. Because if it did that, then it would render Folks and Beer without any application. And it said, if we're going to overrule Folks and Beer, that's a matter for the House of Lords or for Parliament. And in the absence of Folks and Beer, the court was ready to consideration to enforce this contract. Now, as I said, Folks and Beer creates a significant hurdle in the law. It's very unsatisfactory, and that's because agreements to accept a lesser sum in discharge of a larger debt are commonplace. They happen all the time, and parties understand them to be mutually advantageous. So the application of Folks and Beer frustrates the reasonable expectations of parties, and courts have had to figure out different ways of getting around Folks and Beer. So there's one way where they said the promise to accept a smaller amount is enforceable if placed under seal, and that the court didn't have to say that. That is just the general exception to the doctrine of consideration. Another one is if there's a new obligation or thing that was introduced into this agreement, regardless of how trivial or insignificant its worth is, a valid contract would be created. So there would be accord and satisfaction. And the law has accepted that there can be a valid agreement under which the creditor is discharged. The creditor discharged the debtor from liability in return for something of no real value, such as a peppercorn, for example. The court has accepted an exception where the situation involves a composition of creditors. So this would occur where you have a group of creditors of a particular debtor, and they all enter into an agreement that they will accept less than the full payment as discharge of the debts owed to them by the debtor. So for example, the debtor could say, in total, I owe all of you $10,000. I can pay you 20 cents on each dollar that I owe you. And the court has accepted that because it facilitates the realization of the debtor's assets, and enforcement of these arrangements does happen. So these arrangements are binding, even though they appear inconsistent with Pinnell's case and Folks and Beer. Though there are some possible rationalizations to it, which is it's the creditors that provide the consideration to the other creditors, and therefore the agreement is upheld. Or if you ignore the composition, then it would constitute a fraud on. So if one creditor ignores the composition and goes after the debtor, that would be a fraud on the other creditors. Or commercial convenience. So if the creditors knew that the composition wouldn't be upheld, they would all be anxious to be the first to bring a judgment against the debtor. So then there is a commercial convenience of upholding these agreements. In Canada, there was a case in which the court held that the agreement to accept a lesser sum in discharge of a larger debt for practical consideration was enforceable. And they said that this is the Roby Show case, the consideration was the immediate receipt of payment and the saving of time, effort, and expense. So that was just one case. There was another case where in Foot and Rawlings, the court determined that the payment of the original debt in a new form was new consideration. So this is our next case. In Foote and Rawlings, the defendant owed the plaintiff a large sum of money under a series of promissory notes, and the defendant was to pay $400 a month plus 8% interest. The parties came to a new agreement to pay $300 a month at a 5% interest, and the agreement was only valid as long as the defendant didn't miss any of the payments until the full account was paid, and the payment was to be made through a series of post-dated checks. If the checks should be returned as for non-sufficient funds, the whole of the unpaid debt would go back to the previous agreement. The defendant complied with the agreement, but the plaintiff, after cashing one check, decided he didn't want to comply with the agreement, and he sued the defendant for the whole original amount. And so the issue was, is a different mode of payment sufficient consideration for an agreement whereby the creditor agrees to accept a lesser sum instead of that owed under the pre-existing debt? And the court said that yes, you can pay it in a new form, and we will find that to be sufficient consideration. So the arrangement here would continue to bind the debtor until unless the debtor failed to make the payments. Now, this seems a bit absurd, and the exception was not accepted in the English Court of Appeal in a case called DNC Builders, where the court couldn't find a sensible distinction between paying a lesser sum by cash and paying it by check. But what this does is it shows you that there is a problem here. The rule in Folks and Beer is so unsatisfactory that courts seek to distinguish it whenever possible. Now, there is a statute in Alberta, and it deals with this rule specifically. So Folks and Beer is the common law rule, but we've sought to overturn it by statute, or we've sought to enact legislation whereby Folks and Beer doesn't apply. And the statute states that part performance of an obligation, either before or after the breach, shall be held to extinguish the obligation when expressly accepted by the creditor in satisfaction or when rendered pursuant to an agreement for that purpose, though without any new consideration. So that is specifically contrary to the rule in Folks and Beer. The statute is not without its problems. It appears that the provision wouldn't save an agreement under which a creditor completely forgives the debt. Rather, it only mentions part performance being rendered by the debtor. It's not clear whether the provision would save an agreement to accept a lesser payment where the agreement either hasn't been performed yet or has only been partially performed. The statute seems to imply, rather, that the agreement must be fully performed. And the statute mentions nothing about what happens if the new agreement is reached on the basis of duress or unconscionability, though the last part is not that concerning because it doesn't have to mention that. The common law rules regarding duress and unconscionability would apply to an agreement, to any agreement that was made.